start with the last session of the day, which is the professional grab bag. One quick answer from the earlier question from Judge Deal. Next year's conference, and I had this up, of course it's not up now, is December 12th and 13th back here at the Ritz. So please mark your calendars for next year, December 12th and 13th. And to ensure you all get out on time, you can have the rest of your day. Let's start us off.
Good morning. This is going to be an interactive session, so I wanted to get you started early. Let's try that one more time. Good morning. Good morning. All right, excellent. My name is Nancy Rappaport. I'm a law professor at UNLV. I'm going to let my co-panelists introduce themselves, and then we're going to have a catharsis about annoying things that happen in our profession. Judge?
I'm Susan Barrett. I sit in the Southern District of Georgia in Augusta and Old Fort, also in Dublin and Statesboro.
I'm Eric Anderson, partner with Parker Hudson, Rayner and Dobbs in Atlanta. Practice primarily commercial bankruptcy.
Great. So welcome to both of you. How many of you love every single moment of your working day? Okay. Of the two of you who said yes, is that because other people are watching you right now? No, okay.
They don't have clients anymore, too.
There you go. There you go. Of the rest of you, how many of you say you like 90% of your working day? All right, I'm going to do it the hard way. 91 to 100% of your working day. Thank you, Neil. Below 90%. Okay. You're gonna have a chance to vent without using names today. What are the things, I told you, there's going to be audience participation here, so what are the things that irk you? Call them out.
Time entry.
Time entries, okay. Excellent. What else we got? Clients. Yeah. That's on our list. Trust me. What else we got?
Unrealistic demands.
Unrealistic demands. Tell me a little bit more.
Immediate terms of documents.
Okay. Unrealistic. Good. We're covering that. What else? This is going to be freeing for you. It's like a therapy session.
Careless lawyers.
Careless lawyers?
Yes.
Got it. Careless in what way?
They don't fill out the forms correctly.
Right, so sloppy work, not proofreading. Good, excellent. What else we got? I mean, I can come up with a list that's 10 pages long. What do you
tell
got?
them what to do, they don't do it.
Some possibly a little oppositional disorder thrown in. Okay. What else we got?
Last minute amendments.
Last minute
Amendments.
Last minute amendments.
Conference calls.
And I got conference calls. Good. Anything you want to share about conference calls?
It's just an excuse for people to waste time and talk and not actually achieve.
All right, so a chance for people to appear as if they are making progress.
Correct.
All right. That is also true of faculty meetings. What else we got? Yes?
Frivolous objections.
Frivolous objections. Yes?
Lying lawyers.
Lying lawyers.
They say they're going to do one thing and they just do the opposite.
Yep. If you can't count on us, insert lawyer joke here. But yeah, people whose words are not good. Very good. What else we got?
Pro se debtors.
I cannot help you with pro se debtors. Sorry. That may be a pet peeve. It's not on our slides. Okay, let's do two more. Okay. Then I'm going to sit over here. We're going to use the PowerPoint. We're going to talk about a lot of these. But during this, we really want you to talk too. This is an opportunity for us to share wisdom and gripes with each other. And since we're the last session, this is a chance to get it all out. So with that, first thing we're going to talk about is my favorite pet peeve, which is writing ability. How many of you are happy with the level of writing that you tend to see in pleadings, in emails, on Twitter? Okay, good. We're all in there together, and I keep wondering for myself, why is it that we can't write? We used to write back in the good old days when I was a baby lawyer. We wrote pretty well, or at least we thought we wrote pretty well. And now I'm seeing basic grammar rules, just a thing of the past. I'm seeing the inability to communicate in clear, crisp, declarative sentences. And part of the reason I'm seeing that, I think, is that undergraduates don't write very well. So by the time they get to us, they've lost the ability to convey basic ideas clearly. And that's one of the many things that good lawyers do, is to convey concepts in writing clearly. So when you guys think about writing, what are some of the things that irk you?
I think, and I'm going to run the risk, I guess I have become an old codger, but I think it's that the frequency of whether it's first email and then text communication, it seems as though, particularly we almost get made, my kids make fun of me if I actually use periods in texts or capitalized words, and they're not lawyers, but I think that some of that carries over, that we've become so accustomed to shooting off quick email responses. And sometimes in very large or very complicated matters where that could come back to be the operative document, or at least one of them. But I think people fall into a trap of thinking, well, I'm just sending a quick email here. I don't really need to worry about whether my grammar is correct or whether the sentence actually says what I think it's supposed to say. So I think there is some of that carries over, and it's hard to switch from just being an emailer to then putting together cogent sentences and cogent paragraphs into longer documents.
I could sort of think the same thing. It's the difference between formal and informal writing. It seems like that we have no more formal writing, and there seems to be, because of the pressures of time that everybody is under, especially you guys who are making your living off the hour, you don't have the opportunity, or don't feel as though you have the opportunity to proofread and to polish your work. And so I think it's a time constraint issue as well.
And yet these things that are informal, the emails, the casual text, all can be blown up and put in as exhibits to things that happen later. So if we're not careful. I'm curious, how many of you train your new lawyers in terms of how they do emails? Okay, how do you do it?
Well, I don't do as much as I should, but we have had, at least in fact it was my impetus as a part of our firm's professional development program, and we probably, now that you're bringing it up, it probably needs to be refreshed, but we had a lunch and learn session for an hour and a half on those sorts of communications. It wasn't all on email, but some of it had to do with watching what you write. A lot of it had to do with other parts of sort of email etiquette and being careful and not having the subject creep and that sort of thing, where you have one email that gets sent out with one subject, and by the time it's been replied to 14 times, it has something totally different. So we actually sat down and tried to have demonstration and talk about it at a session. And I constantly, on a one-on-one basis with the younger lawyers I work with, try to say, wait a minute, if you let's put this into a Word document first, print it off and look at it, make sure that's what you want to say, and then if you're going to send it by email, that's fine. So.
I think that's a good practice. I think that it reformalizes, to use the judge's conception, it reformalizes something so that you don't accidentally send out a document that then will be blown up into an exhibit later that says something other than what you meant, or said it in an unkind way. Any of you experience unkind emails ever?
And I'll add to that. I'm going to add one more thing. I'm as bad about this as anybody else, but I have one of my trusted colleagues that's in the office next door, and I can't tell you how many times I type an email, and I'm just about to hit send, and then I say, Jay, come on in here and read this for me and make sure that this doesn't sound, and very often he says, you know, I'd probably take that sentence out. I probably wouldn't say what you're about to say, but it's a good check, and I think so I try to encourage others to do the same.
They always end up in an exhibit, and they always end up in court. And one of the things you see happens, like what Eric was saying earlier, is that an email gets forwarded, and sometimes somebody says that person is a jerk or worse, and it's in there, and that's what becomes talked about. It's the forwarding of the email and the reply all. If we could get away with the reply all button on the dadgum phones and emails, it would be a blessing to us all.
That would be heaven. It really would, because we end up saying things in haste. Talking about the pace of practice, we will say things in haste, or we won't proofread, or something like that will happen. And then suddenly there are hurt feelings. The other thing that I've noticed is that when we do have, I'm going to pick on millennials because I can. Millennials have a different way of writing. They do have a shorthand way of writing. And for a boomer like me, when I see bad writing, it does affect my perception of whether the person's competent or not, if they can't convey things well. There's also an informality with millennials that I've noticed over time, where they assume an equality of rank that may not be there. For example, you're talking to someone in chambers. There's not an equality of power. So I love the idea that you do a best practice of helping them understand writing and what it is. There are software tools now that will help people write better, and there's a link to it in, you would probably need the live version of my PowerPoint. I'm happy to forward the link, but there is software that helps people write better if they somehow miss the rules of grammar in K through 20. They can catch it as part of this. And I applaud that. Artificial intelligence, as they were talking in the last session, isn't necessarily a bad thing if it helps us look smarter than we are. But I did want to put up this next slide to give you a friend of mine in a jurisdiction that is not here sent me an example of a pleading she received, and just wow. There are almost no words to show. She underlined this. I didn't underline this, but I did enjoy her underscoring. If you take a, it doesn't help if I don't show you the slide. There you go. Subject verb disagreements. My favorite is she lost his job. That is power. Proofreading feels onerous, but it makes a huge difference in terms of not just the competency implication here, but the credibility implication here. If you can't tell the gender of your debtor, are you paying attention to the other things that are going on? All right, I want to know what, you are now my sample set. When you get a poorly written document, what goes through your mind?
From someone else or from somebody in your own firm?
Both. Oh gosh, let's start with your own firm. What happens when you receive a draft that's just not good?
Well, sometimes I respond to people that, because of the typographical errors and the missing grammar, that I can't discern the meaning. And that's just flat out true. I mean, why am I going to try to figure out what you mean and then talk to some content that I am imputing on you? I just don't know. And I mean, I know that sounds harsh, but I don't know what to say, because it's like, you know, when I look at this, it's like, is there one debtor or multiple debtor? You say good, you say better. I mean, I don't even know what you mean. Who are you talking about?
So hypothetically, so your point is the typographical errors can get so bad that you have no earthly idea what's going on in the document. Whether it's a pleading or whether it's a contract, if it's really bad and really fuzzy, then you are stuck because the written word is the written word. So internally, how do you deal with that? This is, again, participatory. I should tell you my 2 rules as a law professor, just so you'll know them in terms of participation. One is if you make eye contact with me, I'm comfortable calling on you. But the other is if you look away, I'm comfortable calling on you. So with that in mind, and the idea that resistance is futile. I would love to get your thoughts on this. Yes, ma'am.
I'm gonna say I would edit to the best of my ability, edit, and then have a meeting with the attorney and talk about, like, I found this confusing, I didn't understand exactly what you meant. If it's so bad that I don't understand, I would talk to him first before trying to edit it.
It's an opportunity then for you to mentor the person into better writing with the idea that you're actually helping that person's professionalism.
Some of it depends on time and how bad it is.
Right.
Sorry.
Hi, David.
Sitting over in the corner, hi. If the document's so bad and you need to get it on the file, unfortunately, there are times I'll just rewrite the whole thing and just get it done. And at that point, the teaching exercise is a little bit lost because if you haven't fixed the document, you will replace the document.
Right, and you probably didn't do a red line version when you fixed the document to be able to go back and say, these are the 97 errors on the first 3 pages.
No, I say make a new version and send it back. This is what I did so they can run their own comparison. And I also, as a rule, anytime I send a document, I send both a copy and a live link to it, so that the copy's always saved and you can go back and track that as well. But sitting down and explaining it, there's different things. There's just base grammar, which is tough to teach someone who hasn't learned it to this point. But there's also, we talked about this yesterday, persuasive writing. And when I was going back even when I was a law clerk, and I had this discussion with an attorney, 14 years ago now, is that if I'm in a brief and I saw 3 rebooking errors, I'd stop checking your sites, and instead I would just go and do my own research. And so your persuasive writing about your sites are no longer valid to me.
When I get it, I usually think that people are just overworked. If it happens repetitively, then I start thinking it goes to your skill reputation. If it is so sloppy that the order doesn't match the motion, and that happens repetitively, it can get bad enough where it affects your credibility. And it's sort of a scale that goes along. I mean, we understand, and I'm not there to. You guys have got a lot going on, and so when it happens sometimes, we just understand what's going on in your world. I will say that if you have to have a hearing on me not understanding your order, that is a clear sign. I'm not here to babysit you, but it's a clear sign of, look, don't let that happen more than once or twice in your career. If it's unclear, you're asking me to sign it, and I can't figure out whether you're discharging the debt because it's a double negative or something crazy going on, and it's embarrassing to you when you're in court. I'm not there to embarrass you. I'm there to get it right and to help you and your client and all of us move on. But if that happens to you once, I'm not going to embarrass you or anything else, but don't let it, it's not something that should be repeated.
Yes, sir.
Well, I think lawyers don't often, or as much as they should, pay attention to the fact that an order is written by the judge to all the world. And so we are asked to sign hundreds of orders a month, and I just have to bite my tongue and sign them, otherwise I would send 80% of them back. They're awful, but just remember that the order is supposedly the judge's words.
That's one of the things I thought about too, is that you spend so much time in your persuasive argument that the order is just like, throw it together in 2 pages, it's done. But really, that's what you need to spend some time on that order to make it. That's what goes up on appeal, and that's what we're signing. So spend some time on that.
I saw a hand over here, yes.
I want to suggest 2 programs that have given me a lot of confidence, and I usually use these on emails and on their documents. The 2 programs that I use, one of them is called WordBreak, and it is a program that is designed by lawyers for lawyers. And when you break a document, it goes through it and then it highlights suggestions that may improve. One of the suggestions that I still don't ever get right is the passive voice. It dislikes the passive voice, but my objection to their objection is they don't tell me how to fix it. And sometimes the passive voice works. I mean, to me it's better. But it always eliminates, for instance, in orders, and I find in the amount of, it always eliminates that. So it always eliminates heretofore and heretofore and the things that we do. From a grammar standpoint, it does have grammar, but I like to check it against Grammarly. And many of you already have Grammarly. Some of those programs are free, but the free part, I don't think it's as good as what we need. And you don't have to accept it. I mean, it just suggests it, and sometimes the suggestion really doesn't help us, because Grammarly is not written for lawyers, but WordRate is. And I really just hope y'all would just, I get nothing out of it. I'm not a sponsor, but I really enjoyed it. And I look at that thing and think, you know what, that really does make a whole lot more sense than the way I did. And particularly is that true on orders, because one thing that we have to remember is you can't put something in the order that you didn't put in the motion.
Right.
I mean, the judge isn't going to sign that because you didn't ask for it. So be sure it's in there, and be sure that you didn't cut and paste another form that you had, that you settled the case for $65,000, but now this one you're only settling for $6,500. So, you know, those forms are great, just got to make it work for you. But
So the first one is word rate?
it's one word.
Okay.
Word rake.
Rake.
R-A-K-E.
Okay, word rake. And then the second is Grammarly.
It's grammar, which I think a lot of high school students use it. Word rake is really made for us, and some of it, you know, you can take it or leave it, but it gives you that option. You can accept the suggestion and move on. You can reject it and move on. And what you'll find on some of the notices that we send out, they're form notices from the clerk, that we've all agreed that's what we're going to use, but it doesn't like half of the stuff that's in there. Like for instance, there's one that says, you must file a response no later than. It hates it. It always says, you should file a response by, which is clearer to me.
Sure.
And yet not in the form.
When is the response due? It's due by something.
But those are helpful. By the way, you can put Grammarly on your email so that your emails are checked before you go out. That's a handy thing to have. You may not know me that well. I am, at best, persnickety about writing, and I'm going to show you my one-person campaign to fix it. I have taught at 4 law schools, and my proofreading affidavit is something I actually make my law students sign before they give me their papers, because I am tired of fixing certain things. And it's an affidavit because I want law students to understand that if they sign an affidavit and they haven't gone through my 3-page list of things to proofread, I turn them in for an honor code violation because it's an affidavit. They have to sign it, and they have to, I know I'm just a mean law professor. But you can tell that it started with a fit of pique on how to spell my name, which really, if you're turning in a seminar paper, that should be something that you get right from the get-go if you don't want to take it off. But there are other tips that I've developed over time, and the proofreading affidavit is designed to make them better writers by teaching them how to go through something and proofread. So I have quirky little rules about the use of this or that. I want to know what the this is or the that is, so I don't have to guess for clarity's sake. There is no plural possessive of its, and yet it shows up enough times that I want them to search their document for it. I want them to search their document to understand the use of apostrophes. By this time in the proofreading affidavit, you can tell what the peak is. You can get it off my webpage, by the way. But when we're talking about persuasive writing, when we talk about orders, for example, and the judge points out, her name goes on the bottom of that, so it needs to be clear and crisp. The reader gets to decide certain things that the writer shouldn't necessarily foist on the reader. So adjectives that say things like unbelievably stupid. I'm pretty sure that the reader can figure out on a scale of dumb to unbelievably stupid how unbelievable it is. And then I have my one-woman campaign on the word unique. But these are ideas about writing that over time, if we can teach law students how to proofread, they will do better jobs for you and better jobs in front of you. So that plus my campaign on the Oxford comma gives you a feel into the way my mind works. Any other things on writing before we move to the next topic? Any last words? You guys are doing a really good job in participating. I'm very proud of you. Yes?
I have a question. Recently, I submitted a piece I wrote locally with these to a friend of mine who's a college professor. And he said that not only in emails, but also now when you write a paper, it's not expected to be done in space after a period anymore. Have you encountered that at all?
Doug Baird has told me that I am an ancient person for putting 2 spaces after a period. But high school typing is a hard thing to get out of. But how many of you have gone to the 1 space after? Yeah. How many of you are like me and are still Luddites with the 2? Yeah. It's become a thing, though, and when Doug Baird calls you and says, we're not filing this because it has 2 spaces, you go, okay. And you do a search and you take out that extra space and you move on with your life.
It's a storage thing. It's how it's data storage. It doesn't care. It's it doesn't care. The space is taken up space.
It's new word processing. Times New Roman is a self-justifying font.
Yeah.
And so that's what it screws up, is the way on paper.
I did. I don't know if anybody here is from McGuire Woods, but they put on this webinar that somehow or other the court got a hold of, and I looked at the materials that came in about the last week or so, and it had 2 or 3 interesting things that I thought were good. One of them, it was talking about how to write where in today's world where you need to know what's going on, and it said that 90% of your thought process or your thought that you're trying to get across should be in the first sentence of your paragraph, which I thought that's interesting. The other thing it said is it had probably 20 sort of clue words that it said to use, and there were things like above, below, also, contrary. I mean, things that we use all the time, and I thought, well, those things are helpful to tell. We're in a hurry all the time, but you need to understand it. I mean, sometimes I laugh in my office. I have to slow down and move my lips when I'm reading it, and so it just takes time to do that. And how to organize it. One of the McGuire Woods things said, doesn't care whether you use bullets or however you use it. I hate using tables because when it gets up into Westlaw, the tables get so confused I just give up. But it said to use like bullets or headers for your 1 or 2 paragraph thoughts. If you have 6 points you're trying to make and you agree, tell us what the 6 are and put them in little bullets so that you know what section to go to. But I thought it was helpful. Most of it you knew already, but the 90% in the first sentence, I thought, well, that's a good thought process. So I pass that along and give credit to McGuire Woods for putting it out.
Eric, any other tips?
No, I think some of your adjective stuff, I think, is to me that's a process of editing, because I think all of us, I mean, I just had a brief that an associate did the other day, and there was a number of those, not a lot, but a number of those in there, and at some point, not everything is clearly this or clearly that, or we wouldn't be having this discussion, but I think that's why you typically have 2 sets of eyes on everything, because whoever's writing it is getting passionate, and the more passionate you get, yes, it is clearly wrong, and it's unbelievably stupid, and then you need somebody to say, well, maybe it's really not, and it's okay to just say it's, the law says, not the law clearly says, right? But I think, so it's basic rules that we've had, and to the extent that you can find the time and make sure that you're meeting deadlines enough ahead of time to have more than 1 set of eyes, I think it's still the best practice.
I like that. Yes?
Just as a current lawsuit, I wanted to speak on behalf of myself for our writing. I always feel like, one of the more important things you ever do is almost move up your deadline by a day.
Yes.
Because when you're trying to get it done, do all that cutting and editing, going back and forth, and you'll miss an A or you'll miss a dot or something like that. So I always feel like, that fresh set of eyes, that last day actually when it's due, I feel like that really makes a difference between, an okay piece of writing and a good piece of writing. So.
Well, and to that point, and again, everybody here knows this, but the second set of eyes, we've all been through where you go through three drafts of your own, and at some point your eyes just gloss over those things, right? You've read it enough times, you don't really think about it anymore. It sounded good the first time, and it's there, and you don't. So that's why I think you have the fresh set to try to strip some of those things out.
Yes.
So for the people who are not in big firms with other people to look at things, I want to add to the discussion that it's good to get it done a few days in advance
combining your point and your point, the idea of giving yourself time at the end to let it sit and then review it is a great tip to have. I saw a hand over here. Yeah.
Use short words, short sentences, short paragraphs. If you have a choice between an Anglo-Saxon and a Latin word, use the Anglo-Saxon.
Or a redneck word, I'll take a redneck.
A lot of people would say that Anglo-Saxon is redneck.
But you're right, the crisper the writing, the more it forces you to know what you're actually saying, for one thing, because you can't fudge it if it's crisp. But it's all about the reader. When the reader's a judge, you want the judge to know what you're saying and what you're asking for, whether it's the order or the motion. Yes?
On that point, and a little story about myself, when I was a very young attorney, I submitted a form motion to avoid lien, judicial lien, referencing a docket number, and an eagle-eyed judge, who happens to be sitting right there, spotted that we had transposed the docket number in the order. I mean, just like switched two numbers. And I got one of those infamous calls from Judge Laney that no young attorney wants to have. Mr. Laney, there appears to be an error in your order. And so I remember that. That was 15 to 18 years ago, and I still remember, and I appreciate that. That means that those calls from that judge, he's telling you he's paying attention, and that lets you know later on down the road that you better be paying attention. So, yes, the eagle eye and Judge Laney's red pen have kept many attorney out of trouble later on down the road.
Along those same lines, if you use plaintiff and defendant or creditor and debtor, at some point your eyes glaze over it, and you need to humanize that. We've messed it up in our office. If you humanize it, you can still probably screw it up, but it's so easy to just read over that, and then then you just get in a knot at the end of it.
You kind of have to separate out these high volume practices from like the larger practice. I mean, the error is not in the high volume practice where they're dealing with dozens and dozens of cases a day. I get as a trustee very often, I'm a Chapter 7 trustee, if I get pleadings that say Chapter 13 on them, I get a name of a Chapter 13 trustee as a respondent, and the pleading doesn't have my name on it. And, you know, I have to search for why I was even mailed it or something. But it happens all the time. And, I mean, I don't sit there and I pick up the phone, hey, you did this wrong, that wrong. But, you know, you just move on because it's a high-volume practice, but that's sending it to you. But it happens, I mean, almost every day.
I'm still Judge Dallas. Judge Dallas, and the same law firm sits it every time. And, you know, sooner or later, I figure they're going to realize that I cross it out every time. But so far, it's been 13 years, and they haven't figured it out. And I keep wondering whether I'm getting a mustache or not.
I think, this is sort of apropos of nothing, but the most frustrating thing to me, and I have been guilty of it more times than I would care to admit, that the most obvious typo in a pleading or is in the caption or something, because we have seen the brief 7 times, and then you realize that you're in the Northern District of Georgia, and somebody put in there that you're in the District of Delaware, and you've never even looked at the top of the page because you were going right to the substance. So I guess there's always another reason to have 2 sets of eyes and start actually at the top of the page and make sure you're in the right court. Or have the right judge. And
when we screw it up, too, I've screwed up an order where we've gotten an order, something happened in the word process, when we dropped a sentence, that something happened in Word, and it's a long story about how it happened. But we want it right, so if you see us making a mistake that matters, not ruling against you, but a mistake that matters, let us know. I mean, we're mortified about it, and so we make the same mistakes you make, and we do not want to do that. So let us know if we've messed it up.
More seriously, I was looking just before I came here at a security deed. Nancy, that's what we call our mortgages in Georgia, so that's what I'm talking about. And it was not what I would call drawn up by a regular lawyer's bar that does these, and instead it listed the individual grantor and said it was just an individual's name, a Georgia corporation, and then it listed the grantee, who was also an individual, and said a Colorado limited liability company. I mean, so when you develop sloppy habits and then you start preparing documents like that, you're committing malpractice.
So Neil, are you gonna set that one aside too?
We're considering it.
And as we move suddenly to the next section, y'all did a really good job on the writing one. We're going to move to civility and collegiality, which I think has to be one of the biggest pet peeves of all of us in this room. Not because anyone in this room is a jerk, but because we have dealt with jerks across time and across firms. Sometimes our clients are jerks, sometimes it's the opposing counsel. And I do worry about whether as a culture we are losing the grip of what it means to be a professional. We're just not as nice as we used to be. Maybe it's the pace of practice, maybe we're just tired, but there seems to have been a diminishment in the way we treat each other. And my favorite personal example, this happens all the time and I don't have the heart to tell the other side when I get an email like this, is when I've asked because I can't find the email and they send it again and they write, because you don't hear this when you're reading an email. Instead of, I resent the email, but it reads resent. And it just freaks me out a little bit when I get one of those. So, you resent my email? No, 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 they just sent it again. It's okay. But you wonder, one of the things that made me fall in love with bankruptcy law is that by and large it's a close-knit community, whether it's in this state or other states. So it's a group of repeat players who know each other, who can clearly tease each other over time. And so when you've got a bad apple just making your life a living hell, I'm curious as to how y'all deal with the occasional jerk. Y'all want to start?
Well, I guess backing up, I mean, sometimes you just have to grin and bear it, and you know, I try to, as much as I can with some of those people, go the opposite direction and just be as overly courteous and nice as you can, even though it sometimes irks you to do that. I think some of this too, the loss of this, and again, I will sound like the old codger, but I think there is, I just had this happen in a case this week where we were trying to negotiate some provisions in the confirmation order. It started out all by email, and the other side, big New York firm, kept saying, oh, that language is overbearing and it's way more than we need, and you know, we're not going to accept it. And I said, let's get on the phone. And we all got on the phone, and lo and behold, guess what? We actually all agreed on what we were trying to accomplish. And we ended up more or less with our language, but it's so easy for them to just shoot an email back and say, no, that's not the way we do it here, and that's not going to happen. So I think that sometimes you run into people who can be jerks because there is a bit of impersonal part of that. It's all, we do so much now by electronic communication, and that's why, you know, I heard it yesterday, and I say it all the time to young lawyers in my office, pick up the phone.
Yes.
Pick up the phone. People have a little bit less, I mean, in person, certainly most people have a hard time being jerks. On the phone, people have fairly hard time being jerks. But over email or that kind of thing, it's real easy to just fire off something and not be staring someone in the face or even talking to them. So I think I still try to just pick up the phone, let's talk about it. And if we have a disagreement, we have a disagreement, but at least it's not just because they're being hiding behind a computer screen.
I think that's right, and I think you ought to pick up the phone earlier. It's so easy. I mean, none of us are jerks, but everybody else is. And that's the reality of the world now, and the reality of me, and probably the reality of everybody else. But it's so easy to get so bent out of shape and angry at the emails that you can't recover. And so if you right the ship earlier on, I think that you ought to have that personal touch. And now that we're saying that phone is a personal touch, but that helps. As a judge, it is a very hard thing to handle. You try giving the snake eye, you try saying stop that, you do all that, and Rule 11 is the ultimate thing. But you're always faced with, look, if it gets out of hand, do you bring the person back and say, what's your problem, and behave? And then say wherever they are, you've got it in for me, you're going to never like me. It's a very difficult thing for us to handle when you've got somebody who's just totally off the chain. And Rule 11, I don't think anybody enjoys doing that, but we're all going to do that when it gets to that level. The other thing, I hate doing this. It sounds so preachy, and I hate the professionalism because it gets so preachy. But the world, with not getting into the politics of it, but seeing the Bush funeral, wouldn't you all love to have a friend like James Baker when the day you die? And the civility that they talked about there. You know, we're not any more tumultuous than, I mean, we've had a revolution, we've had a civil war, we've had Vietnam, we've had all this stuff, and lawyers have always been the leaders of the society. We're trained to listen to others and be thoughtful and responsive. We're so upset in today's world that the world has become so uncivil and there's nothing we can do. Everybody's just being a jerk. Well, lead in your micro world and be, I mean, we got a new year starting out. Let's be more civil and show the way we're a leading organization. Let's show the way the world how it's done and treat each other the way we should be treating each other. And all right, I'm not preaching anymore, but I do think you're uniquely trained to do it. And think about it, that you're uniquely trained to do it. And I hope there's a Jim Baker when I die. So thank y'all. I'm off.
No, as I get older, I've decided that kindness becomes increasingly important in my life. If you have a choice to be kind, being kind is probably a better way to go. And I think for new lawyers, especially when they get vitriol on the other side and it's a partner screaming at them, they may not have the tools to be able to bring things back to zero. One of the most wonderful lessons of my life, I was a baby lawyer in San Francisco, and I had a partner just pick up from on the other side, just pick up the phone and start screaming at me about something. I do not react well to screaming. And I finally said, you know, you realize this is your client's problem, that you personally should not get involved in terms of taking this emotionally. And he actually stopped and he said, oh my gosh, you're right. And he was the nicest person to deal with after that, because we've reminded him that his clients may be in distress, but he personally could still choose to be a kind professional. And we ended up becoming fast friends because of it. I think that teaching new lawyers that naming the behavior in a way that isn't blaming, but brings people back to natural, can be a very effective tactic. But let me ask you guys, theoretically, when you've had to deal with jerks, what are some of the coping mechanisms that you've used to bring the temperature in the room back down to a normal temperature?
In-person meetings.
In-person meetings, for the same reason that Eric was pointing out, that it's harder. It's just, you can be a jerk in real time, but it takes effort.
It's really easy to hit mute and say something, but when you're actually in front of the person, you can't hit the mute button.
Right. So that's a good technique if you can bring people together in real time. What else have we done?
I think Eric said it, because that's what I do, is we know who they are. I mean, because they're consistently like that, and just be very nice and very polite, and your emails are very polite and very respectful, and it just creates a real contrast. I know certain attorneys are tape recording every phone conversation. I only know a couple of them that do that. I think it's appalling, so I am actually just the opposite, unwilling to talk to them on the phone. And I only will communicate with them either in person or by email. And then I had another from a regional law firm, does this every conversation, doesn't get his way, hangs up mid-sentence with a conference call with lots of people on it, does it over and over and over again. And I'm saying, what are we in the second grade? I mean, this is like, really strange. But I think we get all types. But what Eric said, I think, is still the best way. Just maintain your professionalism, be polite, and just let them sort of stand out very starkly in their own behavior.
Do you think they notice their own behavior?
I don't think they care.
I once had, there was a lawyer in Augusta who no longer practices, but is world renowned for just being very difficult to deal with. And is probably the only lawyer I've ever hung up the phone with. Which I'm embarrassed of. I was not very, I'm embarrassed that I did that when I was a lawyer. But I once asked Judge Bowen, who's a district court judge, and I said, man, he drove me in my carpool. I can't get him to behave. He's so mean. And the Judge Dallas was with him. He said, well, he still calls me Little Johnny. And Judge Bowen said he'd suspend him from court. Nobody could control him. But he finally explained it to me, and he said that there's some lawyers who were taught that unless you go to battle for your client, you're not representing your client. And I never had another problem with him in the world. After I understood that he felt like he had to scream and holler and act like a jerk, then go ahead and scream and holler and act like a jerk. I'm not going to reach you. I'm not going to go to your level. And it was just enlightening to me in simpleton terms that I could understand. So
Don't take the bait.
Don't take the bait, and just realize that some people they are not representing you, especially if it's somebody that happens all the time, that they feel as though they are not representing their client unless they get into that shouting match. Okay, fine.
I wonder if naming the behavior there would ever work by saying, I understand that you feel like you have to scream to be an effective lawyer. Is that what you're trying to do here? Do you think that would make a difference?
In my mind, that was a waste of air.
All right.
But I may be joining in that. But I felt as though that it was, I only have so much air.
Yes?
Okay, so the Atlanta Bar Association has a litigation section, has a Take Your Adversary to Lunch program. And that's designed to help combat this problem. They actually give out, they do a drawing, you put in your name. It doesn't work so well in our practice, because our practice area, if you're representing a Chapter 11 debtor, how do you define your adversary? Because we're not a plaintiff defendant kind of practice. If you have an adversary proceeding, you have a clear adversary. But in a Chapter 11 case, it's murkier. But it's an opportunity to sit down face to face and get to know an opposing party. I've made it, within my practice. I'm a friendly person. I get along with people. I like people. I'm a social person. I get to know people, and it makes practice more fun. And I think it makes it easier to get something done. I think the expression "you catch more flies with honey than vinegar." I can be much more effective for my clients getting along with people. I think the people who are jerks have been jerks since they were 5 years old. And you can't change that personality. That's their personality, and you're not going to change that personality. You can change and control how you handle that situation. You can control yourself. You can't control them. So all you can do is control how you handle yourself within that case. You can't control your opposing party. You can stress out over and get no sleep, or you can just accept that that's who you're dealing with, whether it's in the office or whether it's in court. And you just deal with it by controlling how you're going to react. You do a good job for your client, you maintain your professionalism, and you do the best job you can for your client, because that's the cards you're dealt in that particular situation. And if that opposing counsel is so horrible, if you have the choice, you don't take a case with that opposing counsel on the other side.
I was thinking about that before, Shana, and exactly that program which started in the litigation section. And it's sort of different in our world because you don't always have adversaries, like she said. But I guess I've always been a proponent, sort of old school, participate in organized bar activities. Particularly, I do a lot of ABI things. I do stuff with the Atlanta Bar Bankruptcy section, but I think that's another way, even if you're not going to necessarily do one-on-one to lunch, but if you're constantly working on other projects, non-substantive legal matters, with the same people that you might be adversarial with, again, that's just another opportunity to get together, and if you've worked together to put on a program for the state bar, and then you get into a heated battle with that person over a case later, you're going to say, well, Neil was, we got along fine, good guy. We disagree there, but it's the same sort of thing that I think getting together with, and we have this benefit in the bankruptcy bar typically that it is a fairly small community. But getting together regularly and getting your young lawyers to get involved early in organized bar activities like that gives an opportunity to continually see people in a non-courtroom setting.
It makes them people again, instead of people who are just this monolithic jerk thing. They become humans again. I find asking about people's hobbies is nice, just finding out what they're like as people. For those recalcitrant, die-hard, 100% jerk jerks. It's a little different than people whose behavior you can shape by getting to know them, and I actually have, now I'm talking as a faculty member, when you've got screamers on a faculty and you're alternators, you're going to be with each other forever. I find that telling them, you appear to be upset. Why don't we come back when you're not hysterical? We'll usually catch them to the point where they do back out. That plus I've taught everyone I work with the phrase bless his heart, and they know what it really means.
Nancy?
Yes.
Two things occur to me. One, two of the most strongest words in the English language are, I'm sorry. And so, for example, in Judge Barrett's ranting and raving adversary, after listening without interrupting, so he gets it all out, you just say, I'm sorry that our conversation has started this way. Is there some way we can figure out how to get to the real issue and talk about it? And the I'm sorry is just a trigger, because the immediate response is I'm sorry, it's that's okay. And it's a way of not being threatening to the other side. So that's one thing. And second, whenever you have somebody who's a jerk on the other side and you're tempted to respond in kind, just remember, especially younger lawyers, everybody on the other side of the case is a potential referral source.
I like both of those tips, and it really is true.
And sort of the third one on that is, if the other side's a jerk in court, you don't have to tell us it's a jerk. It's pretty obvious. Silence is good there too. It's pretty. We don't need to be told on that level.
I like that. There have been a lot of good tips here.
And you don't have to, even if they're not a jerk in court, you don't have to point all that out. If they're taking frivolous positions and they don't know what they're doing, you don't have to embarrass them in front of the judge. Because the judge is going to know that. And when you do that, then the judge might start feeling sorry for the judge.
I'll say one of the beauties of our bar across the country, or our bench across the country, is I've never had to go in front of an unprepared bankruptcy judge. You guys know what's going on by the time someone rolls into court having filed 19 frivolous things. You already know. It's like using an adjective. You don't need to. The judge has it. So this is just one of the cases that I mentioned. One of them, by the way, has been reversed. I think it's Ashton, Nevada. But this was the one where you put things in a pleading, and you can look at the materials later. You put stuff in a pleading that you just start thinking, what the heck? Let's see if we can. Where did the? I'll use this one. Where is it? Where did the court get this? This is stated nowhere. Note the nowhere in the report. La La Land, etc. You start getting this vitriol in pleadings, and you know it's not a sophisticated lawyer. You know it's not a well-trained lawyer. But I gotta ask, when you get something like this in a pleading, what's your first reaction that you want to say?
I get up and walk away for a moment. And this is something that some people file this, and this is probably something that you have to move your lips to, because I'm just going to ignore all that and address that somewhere else. But if I'm trying to understand your legal argument, this goes in a separate category, and we're just not going to, I'm not going to bite at that.
I'm curious, there's another case, I think you've recited before, but I remember at the time the French rights, Judge Issacott's case. But I'm curious for you, Judge Barrett, or other judges, these are the ones that people, you put on seminar presentations and you think, wow, who could be so dumb as to say that? But does that happen very often? Or are these just really the outliers?
I've never seen anything like that. I went to baby judge school with Judge Issacoff, and you can say anything you want, but a few fries short of a Happy Meal is not even on the spectrum. I really thought the person must be ill. But I've never had that happen, nor would I ever expect to have it happen, and I thought it was a medical condition of some kind. I don't know that, and I don't mean to be saying that about that person, because I don't know the person, I don't know that, but you're asking me what I thought, and my first thought was the person must not be well.
There's another theory. I've never tried this theory, but the other theory is when you've got a friend who suddenly becomes a bankruptcy judge, and you used to banter outside, and then poof, they have the black robe, and the way that you're used to dealing with them outside court now is a different role entirely. You can find yourself slipping into a very casual shorthand if you don't remember that there's someone on a podium and there's someone who's not on a podium, and there's a differential in terms of power.
And it could be, I mean, it didn't happen in that case, but it could be the same thing about that reply all to an email. You may say that to your buddy, and then sooner or later that email ends up someplace that you had no intention for it ending up. That's not what happened in that case, but it could easily happen on just what we say in emails and instant messages and all that stuff.
There's many of you may be familiar, but just to kind of throw a scare out there, that the worst sort of reply all or good reason not to put things in email was a case that happened in Atlanta, oh gosh, 6, 7 years ago, with a large national firm that had an office here. A lawyer who was not in the firm wanted to make a presentation of some sort, I think was trying to sell some services to the firm. Came and talked to a couple of people that he knew at that firm, and maybe made a presentation to the partners. After that, the person who was making the pitch left. A couple of emails went around, including one from a partner who was probably on the jerk side of things. And he thought, and in fact I think he did only send the email back to the partners, and said some very unkind things about this guy. Well, somewhere along the line, somebody else included the other fellow back in the chain. And that firm and the individual were ultimately sued for libel. I mean, I don't remember how it turned out, but it was in the Fulton Daily Report. It was not a very flattering thing. So even one that he thought was just being sent to his own partners got back, and the person about whom the unkind things were said did not take it very well. So again, be admonished.
I think the thing in the judge from Florida's case, the person was the managing partner of that firm. I think it was a big firm of the head of their bankruptcy section, and I think it cost him his job on that situation. And it could have been, as the professor said, it could have been a joke. It could have been a lot of things. I mean, I can't imagine anybody doing that in court. I mean, who's going to do that? It's just unbelievable. Unless it's a joke or something else.
Or a medical condition. It could be a medical condition. So let's spend a little time talking about what might be some of the causes of incivility, and putting aside the people who were born jerks, because there's not that much you can do about someone who was born a jerk except shun. People don't shun enough in daily life. I like shunning. Shunning is a great, great solution, but no one else agrees with me on that. I think there are a variety of factors that can combine to make you say things that you don't realize are hurtful to the other side. But one of the things that I'd like us to spend a little time on is when you know inside an organization that someone in your organization is a jerk, what should management do about it? So I had a friend who was a summer associate at a firm that no longer exists, and a partner threw something at her. It was either a book or stapler, I can't remember which it was, but it was something with mass. And the good news is, couldn't throw with the darn, didn't hit her. But when you tolerate behavior like that inside an organization, at best you're saying high billers can get away with stuff that the rest of you can't, and at worst you're setting your organization up for a really good lawsuit. So I'm curious to see if any of you have dealt with internal bullies or bad behavior and solutions that you've come up with to reduce their effectiveness as a bully inside your organization, or a hypothetical organization. It doesn't have to be yours. No, you just tolerate them.
Well, it is hard. I mean, you know, it is hard because very often, just as you point out, those people very often control a lot of business.
Yeah.
And you know, we're in law firms. We're in it to make money. So I don't have the right answers because I feel very blessed in the firm I'm in now. But I've been in a couple of firms previously where there were people who, you know, were just jerks, but they also did have very large books of business, and it's a difficult. It's a tough nut to crack because you and at some point, if it's bad enough, I think you just make it comfortable in that, and somebody in management has to say it's time to go, but that's got to reach a pretty difficult level to get to there.
What if it is the manager?
Yeah, well, that's,
It took me 23 years to deal with a bully who was the manager before I finally said I got to leave.
yeah.
It can be really, really hard, but not doing it tells the organization it's okay to have that behavior once you reach a certain amount of receivables. And that's frightening. How many of you have read the book, Eat What You Kill? No, just me. Fine. It's a book about a bankruptcy lawyer who went to prison. It's the Bucyrus Erie case, so it's Milbank Tweed, a partner in Milbank Tweed, where the firm had tolerated increasingly bizarre, bad behavior over a number of years. So by the time it got to a conflict of interest issue in Bucyrus Erie and a hidden order to show cause why the firm shouldn't be sanctioned, the lawyer in question ended up serving, I think, 15 months in federal prison for lying to the bankruptcy court. It started with something that you would think would have gotten the firm's attention. This particular lawyer who practiced in New York and who had for 10 years signed affidavits that said he was admitted to the bar of New York. So, normally you're admitted to the bar when you're signing a pleading saying you are, had not been admitted. He had passed the bar, but he had not made it through character and fitness. So in New York, it's a long process, but he hadn't made it through. So for 10 years, he had been signing declarations that were untrue, and the firm found out. Let me ask you, had that been your organization, what would you have done to that person? Again, participatory. Ask him to leave, right? Any other solutions that you might have done?
You have to read the state bar rules, because we've had to do it at one of the old firms I was with. You may be under an ethical obligation to report them to the state bar, and it can get all of you in trouble with the state bar if you don't. You need to read your state bar rules.
He was billing an average of 3,000 hours a year. They took him out of the partnership track for a year until he got readmitted, and then they put him in the lower partnership track, but they kept him. And that normally is a sign of danger. Do not keep. When you've got someone that comfortable with lying, he said it just slipped his mind, he hadn't actually been admitted. That sort of behavior is a signal that other bad things may follow. And I used to think you could heal people. I think you can help people heal themselves, but there are some people who will not heal. And you want to ask yourself, is it worth it to the morale of the rest of the organization, even if the person brings in millions of dollars? Is it worth it to the morale of the rest of the organization? My conclusion, and I admit I have lifetime tenure at a great university, so it's cheap seats here. I don't think it's worth it. I don't think it's worth it for the other patterns that you put out.
The other thing is, in today's world, as the lawyer in the law firm, if the person is abusive and you've got an associate working for them and they're a high biller and the associates are complaining, I mean, your exposure is just, it's a very difficult thing for the law firm to handle. And I don't know what the answer is, but you've got exposure everywhere you look.
Hey, you look at the world around you, and people who bill high and bring in money, they can be jerks and they get to stay. And people who are nice and don't bring the money and don't bill, they get to go. And that's just in the world. You need to go at CBS and you see that the guy that makes the money, who's the bad actor, bad apple, to go out to get the bad apple out, and the people who weren't the bad apple, they left. And that's been the world for a really long time.
Yeah, I have to agree with you. It has been the world for a pretty long time that the people who have the most power get away with the most bad behavior, by and large. But does it have to be the world? Are there things we can do about it? I saw another hand back here. Yes?
I just think the law firms don't have any way of accounting for the cost of that worker chewing through associates and how much it costs to bring those people through. If you're recruiting at a pretty high level and you're recruiting qualified people, they're getting chewed up and spit out on a routine basis. I never saw that calculation play out. I saw those partners in very long-term. I mean, crazy stuff, like they would
other thing though too, at least in my experience, is like in any other walk of life, any other business, the truth in a lot of these is very often more nuanced, right? I mean, the Galeen thing where it wasn't admitted for 10 years, probably wondered why he never got a bar card or had a number, it might be one thing, but you know, you often have, it's more difficult because there's typically are two sides, and even in cases that I was aware of, you know, the person wasn't just unrequited, you know, wasn't one of these people that was a lost cause. Typically had a lot of things they did really well and were nice to other people, and just had episodes where they weren't. So it's also hard. I mean, we can spout off up here and say, oh, you're going to ask them to leave, but that's not always so easy. It's not quite so clear.
But I think the tide is turning on that, and it's people make fun, not at all similar, people make fun of us for being on the board of 100. Like, I can think of 5 people in the last 10 years that we fired for being assholes.
Yeah.
And then pushed out. One thing, and I say I think the tide is turning, is that it's amazing the effect that Above the Law and Facebook and Twitter and all these other things are having now, where stories are coming out, and clients are pushing for things and pushing to be a better place to work, and they want to hire companies that do well on these very small studies or whatever. And so I think you're starting to see, and I can think of other partners that have had election. I've got a few people that are from New York and have a different way of talking to the staff, and that does not get put up with anymore. And so either it's a conversation, your comp can get hit from an associate to a partner to being asked to leave. I think the tide's turning.
Yeah, I think it is too, and I think that when you do tally up the cost of how many people, for example, how many people in a department have just left over the last 6 months to a year. If they're, you know, if 1 or 2 leave in a 20-person department, people's circumstances change. If 15 people in a 20-person department leave, chances are there's a dysfunction there that you need to figure it out. And if you're management, you have a responsibility at least to make inquiry. Maybe 15 people suddenly had circumstances change, but maybe they didn't. Any last words on civility, collegiality, any other tips?
Just about the Milbank Tweed lawyer, you know, because that's a pretty famous case. So, you know, the judge in Wisconsin made a criminal referral. It wasn't just you didn't disclose, we're not going to pay your fees, you know, which can be a very harsh remedy when that's done. But he made a criminal referral, and what it did was it killed the entire Chapter 11 practice in that whole part, that entire district of Wisconsin. Nobody would file a Chapter 11 case there after that happened, and only when the judge retired did the Chapter 11 case practice resume. I mean, these ripple effects, I mean, you know, it's kind of hard to predict what will happen, but that's probably the most predictable outcome you could have made.
Yeah, at the same point, I get why the judge did it, right?
Right.
It was still a crime. So,
yeah, but it probably knew it would kill the practice too. What?
Our ethical rules require us, if we think a crime has been committed, we're under an ethical, it's nobody's taking joy, we're under an ethical obligation ourselves to report it. So we've got to do it too.
Well, the story was that this lawyer expected at all times that Milbank was going to back him up, and they went running for the hills when this happened. And I didn't even know until you said it that they actually kept him on. I thought he was fired. I had no idea he was still there.
it's a really good book. It's by Mitt Regan, Eat What You Kill. So if you haven't had a chance to read it yet, it's very well researched. He's a guy out of Georgetown Law, and he did a really good job. All right. We saved up client management as our next topic, and I'm sure all of you love all of your clients all of the time, but occasionally you might find what we used to call a statistical sport, where you've got a client who's overbearing or intrusive or calls you 20 times a day or texts you and then wants to know why you haven't texted that person back in the last second or two after you texted. There are a lot of things that go into frustrations with clients. When we were doing the survey at the beginning, clients was number 3 on the list, right? Unrealistic demands, things like that. So I've noticed increased client pressures as the ability to search for lawyers across firms has gone up. clients can go a lot of different places, and so they tend to put additional burdens on practicing lawyers to do it their way or go the highway. Have you guys noticed that as well?
Yes.
Thank you. Again, participatory as part of this last session. So what are some of the things that you've noticed in terms of client behavior that may have changed over the last, say, 10 years?
I'm not sure it's necessarily, well, there are obvious, what everybody here had, and several people said was, you know, that with the speed with which we communicate, you know, you get a document sent to you or comments sent back from a client at 10:30 at night, and they wonder why before 6 in the morning they haven't heard back from you. And that can sort of get old, although I think some of the clients, obviously, we like working for best, you know, some of that's gotten better. I think one of the things that I have found most difficult, and I've had a couple of examples of this over the years that are very tough to deal with, is the client who can have the luxury of sitting in his or her office in New York and be directing you to do things, and you've talked about it in here and in one of your articles about, you know, well, you tell that judge that this is what we're going to do. And easy to do that when they never come to court. They're not the ones that have to face the judge. We had a situation in the case that where we were close to confirmation of a plan in a case in Florida. We were lender's counsel, and at the last minute, after we had told the debtor's counsel we were in agreement on the plan, and literally the confirmation hearing was on Monday. Sunday night, the client pulled the rug out from under me and sort of said, we're not going along anymore. And the best thing that the court did there was, because the debtor's counsel was understandably and justifiably upset about that, the judge said, well, I'm going to order the parties to mediation, and I'm going to order Mr. Client to come here personally. Well, guess what? That settled really fast because he didn't want to show his face, right? So but that does repeat itself some to me, where you have people who, you know, a lot of times we don't even go to court that much anymore. Sometimes it's just telephonically, things are resolved out of court, but where there's never those, we come back to this personal meeting thing. And clients, you know, we represent a lot of lenders. There's a lot of sort of old school asset-based lending people, workout guys that, you know, back the brass knuckles kind of approach, and they just want their lawyers out there to be bulldogs, and they want to continue to tell you to do, you know, things you don't really think are appropriate. I guess as I've gotten more senior, I feel more comfortable saying that's really not the way to do it. But it is always a tough spot. You risk that they might just say, well, fine, that's the last thing I'm going to hire you on. But I guess I'm also old enough that it's like, that's fine. I don't want to really deal with you anymore. But that's hard, right? Because there's not as much business to go around, and so it's easy to sit up here and say that. It's another thing when you realize that's a client that might not pay you any more money.
Judge, I'm going to put you on the spot for a second. I'm sure there are times in a hearing where you see a lawyer being uncomfortable making an argument with the client in the back row, and you can get a sense that it's because the client is really pushing an argument. Do you ever engage in some sort of signaling function saying, you know, that was a bad idea?
I wouldn't call it signaling function, but you do appreciate the lawyer who says, who lets you know, ethically lets you know that they realize that this is probably not exactly how they would want to argue. You understand that, and you understand the position the lawyer's in. I mean, we've all been there. We know what's going on. And if it's not your best argument, we appreciate you telling us it's not your best argument, and you're doing your duty. So I wouldn't, it's signaling through what you say and your reputation before you precedes you. And so it's sometimes a more seasoned lawyer does a very good job at that, and it's helpful, and everybody knows what's going on. There's nothing unethical about it, and it just helps the process. And you, as a judge, we're trying to make everybody do the best job and look the best they can. So we appreciate it if that happens.
The code word is my client wants me to tell the
Yeah.
court.
And if they do a little shoulder roll or something like that, you sort of know. Yeah. And it's a total.
And that happens for both debtors and creditors.
Yeah. And usually if it's a debtor situation, I frequently will talk directly to the debtor in that situation to try to, we understand the pressure the lawyer's under and are cognizant of that.
So there's a range, right? There are arguments that you want to make because you know they're good arguments. There are arguments that you make because your client really wants you to make the argument and they are within the zone of reasonableness. They might be on the far end of the zone, but they're in the zone of reasonableness. And then there are behaviors that you just can't do. And Martinez is one of my favorite cases on this. In a stay relief motion, they attached the wrong parcel, and they realized, oh no, we don't mean that we want this parcel, we want that parcel. And when the lawyer for the creditor was told, hey, wrong document, they said, well, our client won't let you, our client won't let us swap it, even though this is not the parcel we were talking about. And the judge, I don't know if anyone follows Judge Markell opinions in particular, but he was quite well known in Nevada until he became a law professor again. He said that's just a bridge too far. When you know that you've done something wrong, just because your client says you can't fix it doesn't mean you shouldn't fix it. So there really is a bridge too far for some of these, and Martinez is a good example about that.
We've learned, we had a bankruptcy Southern District meeting met earlier today, or earlier yesterday, and one of the things we talked about that's interesting is the creditors bar. There are more and more lawyers on consumer matters who don't have authority, nor does a lawyer in Atlanta have authority, nor the lawyer in Houston. And it's so the authority to change documents and that stuff, it's I don't know how y'all are handling that when that goes on, and whether you just ask the motion to be denied or what position that puts you in. The person who was explaining it to us was talking about the new federal laws on how, I didn't understand it all, but the finance laws on it required that, and that there was something that the banks were putting on them. So I don't know how the creditors bar is handling that. Has anybody got any insight on that? Are you really not having authority, and what does that mean? As Judge Coleman says, if you come to court, you have authority, and sooner or later, you're going to have authority. So I'm not quite sure how it really works in the real world, but it does seem to be a problem.
Thoughts? Yes?
When you're acting as local counsel to a firm that's from outside, they're filing pleadings in your district, but they're never going to show up in court, so they engage local counsel. I've done that where I'm explicitly told you don't have the authority to sign off on a pleading that binds the client to some sort of outcome, whether it's granting stay relief or through the cure order that cures the arrearage. And what do you do? I mean, I try to work through it as best I can, but again, I'm hearing things, especially with respect to mortgages, that it's the mortgage lender that's under the rules, and the firm that has the referral to file the motion for relief. They're trying to do what the client's telling them, and then that trickles down to, or they might have to get approval of an order from the bankruptcy department of the lender, and so even the firm that's outside of Savannah, they don't have the authority. They're being told, we got to approve the order. So it slows the whole process down because everything's going up and down the chain of command, and
And then the numbers are stale. The numbers are stale by the time you have the authority, so it's a circle, but it's a...
And I don't know if there's the local rules or something has to be. There's got to be something in the rules that says if you show up at a hearing, you must have authority to work this out. I mean, that would certainly give
That would help.
I mean, isn't that what a lawyer showing up in here and doesn't the bar run that? It's awkward because we don't want to put y'all in the situation, but I think Judge Coleman's right. If you show up for a clear hearing on behalf of a client, you've got authority.
Well, they have authority, but to represent the client. But what that client is saying is you can't make a deal.
You only can ask for a continuance.
You know, the code word I hear is I don't have authority for that, Your Honor, which
Yeah.
tells me this is a perfectly reasonable solution, I just can't agree to.
Right.
So when that happens, then I just say, great, it is order.
Yeah. What happens to us is they don't know the number, and so they aren't entitled to relief, and they don't know the number.
Well, that's another problem.
Yeah.
But it does put you in a horrible mind.
For those people here, and the people who are here who represent the residential mortgage lenders, they're not the ones who should receive this message, but that method of doing business in bankruptcy courts is not calculated to produce a long-term favorable result for the mortgage lending industry.
That's right.
One of the solutions we talked about at this meeting, and I don't know if it would work, but having a local rule requiring them to put a payment history on their motion for relief. And so then you're only dealing with 30 or 60 days worth of numbers.
I would assume they could produce one that's something.
Well, that's another issue. But if you put that burden on them, yeah, it's somebody be able to understand.
There are other jurisdictions that just have mandatory mediation on some of this stuff.
But it's horrible for the lawyer who's trapped in the middle there and whose reputation is on the line, and the client is just, it's as if the client has that lawyer on a leash and is jerking the leash all the time. It's really hard for the lawyer. You were going to make a point.
No, I was just going to say that even getting the up-to-date arrearage figure doesn't, I mean, I'm frankly told that I can't, even if I had the information to resolve the matter and draft a cure order that everybody agrees to, I'm told I can't sign off on it. It's got to be approved. Even the arrearage has to be approved.
That's not a problem. We'll just have a hearing, and the only witness will be the debtor, and I can predict that outcome very
It's tempting to do that, but you're scared of what you're doing to your local bar too. And so it's as tempting as that is, you're not sure that's the right solution either.
Well, I touched a little bit on Aston, Nevada, mentioning that it had been reversed, but the one fun thing, it's just a factoid. Judge Markell had very creative ways of sanctioning bad lawyers, and among the sanctions in that case was he actually said, you know, you say you do bankruptcy on your website, but I do not think you do. And so you must take that off of your website now. And that was always just a classic Markell order. I want to end this session by just a laundry list of things not to do. These are just some of the ones I came up with, but I want to see if you have more. We'll start with how not to irritate judges. And the list of the PowerPoint is some of them, but I'm wondering, what did I miss other than the ones on this PowerPoint? What are some other things you've learned over the years not to do when you're dealing with a judge? Yes?
Make excuses like my secretary didn't count it. You never say that. That's just that's a death sentence. I mean,
Rule number one, you do not blame support staff. There's actually an ethics rule that says you have to supervise them anyway, so blaming is a bad idea. Good. What other ones we got? This is where judges can also pitch in and say things that irritate them.
Regarding a sentence with all due respect.
Oh yeah. Is there a judge in the world who does not know what with all due respect actually means? Followed briefly by the sarcastic, thank you, Your Honor.
Or this is how we do it in the Southern District of New York.
Ooh, that's a bad one. Do we have others?
I've had a more serious thing happen recently, and this is two really good lawyers, but for some reason or other, they had sent me ex parte emails. And I don't know whether it's a generational thing. It doesn't have anything major to do with the case, but it's happened twice in the last month, and I don't understand it, and that is not a good thing. One of them had a bunch of personal stuff on there. I usually just put it straight on the docket, but one of them had a bunch of personal stuff, and so then it put me in an awkward situation to do I put it on there, but they got my personal email, and so there wasn't a filter at all. And so I don't know if it's generational, but the higher ups in your firm need to make sure that the younger people, that the lack of formality and the difference between roles seems to get blurred with the younger people, and this is something that I'm shocked that we have to remind everybody, but that's one of the things you cannot do.
Any others?
Yeah.
I would say that not deferring to the judge or arguing with the judge. Like, no, you got to read what's going on, and you're losing or you're winning. No way that's happening.
Yeah, paying attention to the questions the judge is asking, and maybe not going all the way to feed French fries short of a Happy Meal, but pushing back so much that it's not a good call in terms of strategy.
Not knowing your client, that's really offensive to me. When you turn around and have to say, oh, it's John Smith in the courtroom, and you know, you're getting paid. I know the consumer people have got a lot of cases, but know your client. That's just embarrassing. They're your client, and you need to know.
Judge, we, at the 341s in Atlanta, the trustees have to introduce the attorneys to their clients.
In Las Vegas, there is a law firm that gives color-coded folders so that they know at least which people are their clients in the 341 because they've never met them before. Las Vegas is just different. Okay.
Be careful using a conference phone or a speakerphone because a lot of them, when you speak, it turns off the other way, and so there's a chance of a judge. We had a judge once who actually hung up the call on someone on a speakerphone because they wouldn't stop talking and she couldn't interrupt.
Wow, that's a good tip.
That actually happens a lot.
A lot. Picked up a lot of phone.
I was in a huge closing once, and it was at one of the big firms it's not yours, but it's not yours, but it's a big firm in Atlanta, and an associate was intentionally listening to the other side of the conversation. So much that the banker client, his own client, got up and hung up the phone. And that is an ethical thing. It was unbelievable to me, and I think it cost that big firm that client. And it was Wells Fargo.
Judge Massey, to David's point, one time the person who was speaking wouldn't come up for air and give the judge a chance, and so the judge said when he finally did, "This is the last time you can appear telephonically. From now on, you will appear in the courtroom."
Wow. Well, the last slide is also a reminder that it is possible not just to alienate judges, but to alienate senior lawyers, and this is a laundry list of things I came up with. Again, to me, the biggest mortal sin is blaming support staff for something that's ultimately your responsibility. But the other ones were very freeing for me to write as well. With that, I believe we are done. Thank you very much for being participatory, and I want to thank my